We're hearing about some potential defense strategies for former UFC champion Cain Velasquez. A judge in San Jose recently denied him bail. The 39-year-old Velasquez is charged with attempted murder for allegedly chasing and ramming his vehicle into and then firing shots at Harry Galarte and his family during an 11-mile high-speed pursuit that stretched to San Jose. Galarte had been accused of molesting Velasquez's underage relative, but a judge released Galarte with no bail and ordered him to wear an ankle monitor. The judge called Velasquez a substantial risk to public safety and to the Galarte family and said Galarte's case is irrelevant to the bail hearing. KPIX 5's Kiet Do spoke with the co-director of the Stanford Criminal Justice Center, who offered up some theories about Velasquez's defense strategy.
I take it that self-defense as an argument on Velasquez's part is pretty much, untenable, out of the question. Crime of passion, maybe?
Well, let's talk about what crime of passion means here. First of all, of course, and I know you know this, and your viewers probably know it, but we're using the term self-defense in a certain way here. It's defense of others, but the standard is pretty much the same. In other words, if I come upon you and you are doing something which leads me to reasonably believe that you're about to commit grievous bodily harm on another person, especially if it's a relative of mine, but wouldn't it really have to be, then I am allowed to use deadly force against you, okay? Almost all deadly force cases or self-defense cases, for convenience, let's call it self-defense here, require imminence and almost simultaneity. In other words, the necessity rationale is that I need to use deadly force against you right now, because if I don't right now, you are about to commit the harm on the innocent person. That's a very general rule, and it's a very good law. The only exception to it is in a circumstance that's not applicable here. Your viewers may be familiar with the often litigated battered spouse syndrome defense, or the battered spouse defense, where victims of spousal abuse have made successful self-defense claims in using deadly force against their abuser, even if the abuser isn't attacking them at that moment, or even in some cases where the abuser is asleep. The argument there is, in a sense, this is immediate necessity. Maybe they weren't about to be attacked by the abuser at this point, but they had no alternatives. There was no other way of doing it. And typically the argument, quite plausible, is it's not as if we could escape the harm, and so on and so on. This is a very different situation. The crime of passion point is interesting, and the legal doctrine would be a little clearer if somebody had died. Fortunately, nobody did, but it would be a species of voluntary manslaughter, sometimes known as heat of passion or provocation cases. And the argument there is the defendant admits that he attempted to kill. He took action intending to kill. He isn't saying that a reasonable person would have killed. I mean, that's what he'd like to argue under self-defense, but let's assume that doesn't work. But, and here's the little calibration here, he'd be arguing that a reasonable person would have been provoked to such outrage that he would have been tempted to kill. The fully reasonable person would have overcome that temptation. But a reasonable person might be susceptible to that temptation. So the result is we split the difference. A case that would otherwise be intentional murder becomes something called voluntary manslaughter under the heat of passion rationale, and the sentence would be lower. This isn't a homicide case, but you could find a compromise parallel to homicide cases, changing attempted murder to some species of assault. And that would be a way of splitting things on a passion theory.
What do you think this is going to do to vigilantism, this idea that we need to take matters into our own hands?
Well, I've seen some of the public responses, particularly from his fellows in MMA, but others, in the media. This just happens a lot. Now, in some ways, it's just noise. And by the way, obviously, there's very strong evidence to believe that a horrible molestation occurred and the molester deserves terrible punishment. There's no question about that. I'm putting that aside. But the vigilante idea is sort of part of American iconography, going back, to our notion of the frontier days. And frankly, even that's kind of mythical, what happened on the frontier days, We know it has a lot of popular cachet. We remember the Charles Bronson movies, and the vigilante always becomes a kind of moral hero. So some of what we're hearing is just people playing that out as noise. They're sort of performing it. But the impulse really is there. And what you have here, and it may depend on the outcome of the case, is whether in future cases where somebody might be tempted to vigilantism, will that person be incentivized to do it by seeing what Mr. Velasquez did? Obviously, if Mr. Velasquez is seriously punished, one might say that those future vigilantes will be deterred because they'll realize they might be punished. But sometimes deterrence doesn't work. Sometimes what's more in people's minds is inspiration from what he did, not a fear of being punished if he is punished. So it has it can have a very invasive psychological effect. Another possibility is, if I'm tempted to do this in a similar circumstance, even if Mr. Velasquez is punished, I actually think of him as having won because he won in the court of public opinion. He's a hero, and I want to be a hero like that. So there's a kind of martyrdom aspect to it. So it is worrisome in terms of what it might encourage, but it's very tough to predict how and where.
The defense attorney, Mark Garagos, said that what's happening is it's proof that everything is upside down, that it is a, quote, perfect example of why the criminal justice system is irretrievably broken, that his client is in jail, but a man like Mr. Goularte is out free on no bail. Care to comment on that?
It's all a question of, what came before the bail judge, in the Goularte situation. I'm not well informed about that. I don't think it's so much a matter of balancing one against the other. I think it's a matter of taking each case on its own. And then if there's reasonable criticism of the no bail requirement decision or the release decision in the Goularte case, that it should be looked at in that regard. It doesn't, I admit, it does not look great. I mean, the comparison doesn't look great. To use the cliche, the optics are bad, but the two cases have to be looked at separately for bail purposes.
Velasquez will stay in jail at least until his next court appearance. That will happen on April 12th.